Hello, everybody.
Yeah, if you let's call this 25F0307GZ Warehouse LLC versus Tanya Marie and Brian Lee Allen.
Your Honor, for the record, Attorney Ian Morton of Pallett's Law on behalf of GTSC Warehouse LLC.
Thank you. And we have Brian Allen and Tanya Allen here in the courtroom. All right. So here is where we are and where we are last time. We were here on July 28th and defendant was paid $3,284.82 into escrow with the court. Defendant or plaintiff's attorney to provide a breakdown of attorney's fees. And we would return for a decision today. Is that an accurate statement as far as you know, Attorney Morton?
Yes, Your Honor. Yeah, the decision, the 328482 was not was it disputed in regards to what was due through the month of July, and then the court should have received our breakdown. I know I mailed, but also emailed a copy to Mr. Allen as well of the breakdown of the legal calculations. We also included the support for the claim, i.e. specifically the contract terms, as well as an affidavit.
All right, thank you. And Mr. Allen, what would you like to say? Did you pay that $3,000?
No, I can't get the funds released until 28th is when my institution will allow me to grab those funds. So I can't even do anything until the 25th. And then I would pay it myself, but I can't do nothing until 28th at the financial institution.
So remind me, you stated that you did have the money and that you had placed it into your own type of escrow.
What I did, ma'am, was I had it set up to where it was like kind of like a loan type situation where I had because the vehicle with Creekwood, and this is where Creekwood and they say is not the same, but it is. So I had it set up to where the funds would be available to me, and I thought they were going to be ready for me before then. Anytime I asked for it, and they said no, they weren't going to be still until the 28th. So,
did you get a copy of the plaintiff's brief in support of request for an award of attorney's fees and costs in the accompanying documents that went with that?
I got the email today. I haven't got the thing. They said in the email said something about it being sent FedEx, but I haven't received it by FedEx yet. So
I do note that it was filed with the court on August 12th, so just a couple days ago here. And I'm assuming that you want to respond to that. Is that true? Because that was something you were contesting?
yes, ma'am. Yes, it was. In another light of that too was I'm working on the phone records and stuff because I think that needs to be part of this, and I'm waiting on those records to come back from Xfinity. I had to have because I need them for court, and I wanted to have proof that these are their records, not mine. So because that was a part of this whole deal, that if the attorneys would have responded back in December when they sent the letter that I have here, which I don't think you have a copy of, Your Honor, stating that I need to contact them and everything else. And this is when it all started. And this is when also the stuff with Creekwood started at the same time, right around the same time, where we tried to contact them and everything else, and they didn't respond that one time. And my phone records and everything was to show that they didn't contact us or anything after I reached out at least 8 different times. So
Well, I'm just gonna interrupt you real quick because it sounds like we're not ready to forward on the motion yet, and so you need time to do all of that, get that information to me. So I would propose that we are looking at an adjournment on this matter. Attorney Morton?
Your Honor, I feel it's appropriate to say, and again, after the last contentious hearings I saw, I wanted to make sure that I wanted to give Mr. Allen the full chance to be able to speak. I also want to clarify, first of all, his accusations in regards to shared companies and things like that are baseless, and there's no support for that. And I feel it's necessary just to formally put that on the record. Second of all, Your Honor, he violated the court's direction in regards to placing those funds into escrow. He said before at the last hearing, as the court put on the record that he would place those funds into escrow. He failed to do so. This is a possession-only action for a judgment of possession. I think it's appropriate, and I understand the court's going to weigh different factors. I do think it's appropriate that, that a judgment of possession be entered based on his failure to follow the court's direction in regards to simply placing those funds into escrow. This is a reoccurring theme in regards to statements of offering to make payments and then maybe adjusting the amount he's going to pay and then saying he can pay an amount and then not paying the amount. It's a reoccurring theme, Your Honor, and that was only what was due through the month of July. At the last hearing, and I'll let the court review its own records, the court said, look, there's no dispute. There was a default. The amount due was the amount due. He was required to put that into escrow. He didn't put that into escrow, to just minimally move forward to not have the judgment of possession entered. So as of today's date, Your Honor, I think it's appropriate, and I would ask the court to enter a judgment of possession for this matter. If the court's not going to entertain that today, over, as the court understands, over my request and my client's request for this, I would simply ask that, first of all, there's been now we're in the month of August, another $285.86 have come due because that balance that was provided was through July. And this is only for the payments towards the balance due. So we would ask that, maybe if the court's going to adjourn it, an order gets put in place this time, so it doesn't become a continuing issue where he makes a promise that he's not able to uphold.
I thought, did we not reduce what I had stated on the record last time? Did we not reduce that to an order that $3,284.82 would be paid into escrow with the court, and that plaintiff's attorney would provide a breakdown of attorney's fees?
I don't believe that was put into a formal order, Your Honor. I believe based on the turnaround time, the court simply gave the order from the bench and provided that, was it to both parties? If the court put in an order, I would say that and there was an order in place and that order was violated.
There should have been one, and
It was one of the problems I had, ma'am. I thought that I was told that the attorney was going to do it, and I came in here looking for it, and they said it wasn't done. So I had to actually they gave me a copy of this that you put, so I could try to get the help just in case I couldn't get it done. So there was no order done, and just that you put this on file, and that was it. That was one of the problems I ran into too. So I thought the attorney was going to do it, and that's what I was told by the clerks. But she said,
well, I don't know if I wrote down that or not, so I don't want to say who was supposed to do it or who wasn't. So here's what I'm going to. I'm sorry, Mr. Allen. Was there anything else you?
yes, ma'am. And just to go back to where he says there is nothing between the two places, there is, because in my current agreement or contract with Creekwood or with the mortgage company, I can't sell my house unless I let Creekwood have the first option to buy. If they're not in cahoots with each other, then why is it in my contract that I can't sell my house to you or anybody else?
Yeah, but that's not really in front of me right now.
No.
That issue is not those issues are not really in front of me right now.
Well, I understand. Maybe I get that wrong. I'm just saying that they said they're not together and they are.
I mean, if there's some other type of claim, I don't know. There's some other type of claim that you want to make or another type of issue. I mean, suppose you could put it in writing. What I'm going to do is I'm going to adjourn the matter for the reason that the court did not get plaintiff's brief in support of requests for an award of attorney's fees and costs. And that's just what's written on the front of what I'm looking at here. I didn't know that this was actually in the file, so I haven't even reviewed it. I know that defendant has not had the opportunity to review it. And so I'm going to adjourn to give the defendant time to respond to that. But I am going to not make a decision. I'm going to note that plaintiff has addressed the fact that defendant didn't put the money into escrow that was supposed to be put into escrow, and I'll make a decision on that issue and whether that is violation of what the court ordered when we come back to court next time. So what I'm going to do is this, I'm going to adjourn this matter to September 8th, 2025, 10:00 a.m. And that will give Mr. and Mrs. Allen you time to respond to the attorney's fees requests. And that will, I'll make a decision at that time whether or not you're in violation of the court order by not placing the money into escrow. You can put the money into escrow between now and then. That would be a smart thing to do because it's still an order of the court that you're supposed to do that. And obviously it's not going to go anywhere when you place it in escrow with the court, right? So it's going to sit there as it should be sitting somewhere right now anyway. But I still need to make a decision on that issue at that time. And like I said, I'm gonna hold my my ruling on that at this point. So do anybody have any questions about what I've said?
No.
Your Honor, if I could just get two clarifications.
Sure.
The first one is, so was it, I wanted to clarify two things, I guess. First of all, the 328482, I understand the court's going to reserve its ability to be able to make a determination on a violation that occurred. I do want to make, I want to make the courts aware and make sure the other party's very clear that that was what was due through July, August, and now with the new hearing date coming in September, those amounts will have come due. I'm not necessarily going to amend the the attorney fee list, Your Honor, because if the court, the court didn't have a chance to look at it, but there's already a governor, on the attorney fee capability of a 15% cap related to the total due on the loan itself, which is all in there that the court can review and Mr. Allen can review. So at this point, there's nothing really more that's going to be collectible specifically in regards to the court cost side, in regards to the contract terms that are being followed. So that's in there already. So I just wanted to say that I wasn't going to seek to amend the that balance at that time either, Your Honor. And then finally, that I just also want to make sure this was brought as a possession only action. So I know we're going through the amounts to give Mr. Allen potentially the opportunity to be able to continue on with possession of the home and continue the tenancy. But ultimately, depending on where this goes, I think it's been clearly established the default did occur, but I understand the court's procedures and where it's moving forward with right now. I just wanted to felt it was appropriate to mention those select things.
I think those things that you just stated are accurate. And what I'm going to do is I am going to do an order reiterating what was placed on the record last time we were in court. I will also include that August and September. If they do become due, they need to be paid into the escrow as well. And so that those things are clarified.
Thank you, Your Honor.
Okay. All right. Very good. All right. Then we'll see. And we'll put the next court date in that order as well. But go ahead and stop the clerk's office anyway. Okay. All right. Thank you.
What was that time again? Just to clear.
September 8th at 10:00 a.m.
10 a.m. Thank you.
All right. Thank you, everybody.
Be safe, be well, sleep sweet, and much love.